All right, everybody, welcome to the Creative Finance Collective. If you're just now joining us, this is the Creative Finance Collective, and we're getting together to talk about all things creative finance and take your questions throughout the hour. We're going to be here for an hour or until we stop getting questions or cease being interested in what each other has to say. So got a few people here today. I'm Andy Fowler. We've got Sean St. Clair, Alan Seschker, and Drew Jenkins. So we've got some lawyers representing at least 4 or so states, 4 or 5 states. So we're here to take any questions that you have. Make sure to put those in the chat. Also, just a couple housekeeping items and reminders. There's a barcode at the top of the screen. That is a barcode for you Facebook or other users. That barcode will take you to the YouTube channel, allow you to subscribe. And that's generally the best place to interact with our content. But if you're on Facebook, you can still post a comment, and we will get to any questions that you have. So go ahead and post those. Sean, Drew, Alan, how's everybody been doing?
Good.
What's the latest in the creative finance space in Texas, Alan? Any still big deal there?
Well, yeah, certainly a big deal. Recently learned we may be changing our trust structures. Was talking with Sean about that, but that doesn't really affect the folks. That's behind the scenes. Still quite popular. One thing we found is, I guess if I don't name names, an underwriter that will insure FHA and VAs. So that's good. That's about all.
Who is that underwriter?
No. I've been told by several levels that this isn't for public consumption.
Understood.
Interesting. Well, that's good, and they will insure it as part of the closing, or do you have to close and then insure the recorded deed?
So that's interesting. You say that. So they will insure as part of the closing. The reason I say it's interesting, we're actually trying to sell a house up in Alaska, and the way that they do it is they have their escrow offices, which conduct a closing, but they don't provide title insurance. And then they walk across the street to the title insurance company and say, "Hey, get us title insurance on this." So that was new and foreign to me.
Yeah, that's how
we've.
Go ahead, Drew.
I was going to say in Alabama, obviously we actually can insure foreclosures, and obviously you do that after the fact, right? So somebody they buy at foreclosure, and then after the fact they call and say, "Hey, can I get insurance on it?" I mean, obviously, it's kind of a yellow flag that it wasn't insured earlier, but it's still something that we're able to insure. So every now and again, somebody will walk in and say, "Hey, can I get insurance on something?" And of course, the first question is, "Why now?" But so long as title pencils, there's nothing wrong with it.
So I'll update how that goes. We don't have a buyer yet for it, and so I don't. When we were trying to find a RAP friendly or RAP knowledgeable title office, they didn't exist. And when we were trying to find RAP knowledgeable real estate agents, they barely existed. I guess I'm talking about the largest state in the universe. So I guess this is in Anchorage, Alaska. So we finally came upon a real estate agent that understood this stuff. So we'll update as we go along. We're hoping to sell it seller finance wrap, probably do a 30-year note on it and see how it goes.
All right. So if you're just now joining us, this is the Creative Finance Collective. We're taking questions regarding creative financing. Guys, we have a few questions, so let's get into them. First one, I think, is a follow-up, Sean, to our podcast earlier today, which was all about powers of attorney. Will a general durable POA allow my agent to act on behalf of my LLC that owns real property? I know in a lot of subject to transactions, well, Alan, he was just talking about trust. Oftentimes we're dealing with an LLC. Is if something happens to the principal, is a general durable POA going to be sufficient to allow them to allow their agent, I think here, to act on behalf of their LLC that may own this investment property?
So to follow up on the show today, I mean, a power of attorney, at least here in Arizona, the agent has to be an individual. You can't have an LLC, but you can appoint successor agents. So you can say, okay, well, if it's not me, then it's my right hand person. If it's not my right hand person, it's my left hand person, and you can go 2 or 3 deep on that, and have successor agents. As far as the ability to act on behalf of an LLC, LLCs can't give power of attorney. Instead, the way to allow someone to act on behalf of your LLC is twofold. One, you can have an operating agreement that gives them that power, and names them in the operating agreement as, say, a manager, or somebody having the authority to act. Or the second is to do a resolution, which gives them the authority to act. And the resolution has to be signed more likely than not by all the members of the LLC, and it's called a resolution. Then you have to put in there that you're doing an action without a meeting and that type of thing. So, but operating agreement or resolution allows an individual to act on behalf of an entity.
I second everything you just said. Just down here in Georgia, we would call it for LLCs an action by written consent, right? We're going to leave the resolutions to the corporations, and for the other entities, it's going to be either action by written consent or action in lieu of a meeting.
So your own personal POA as part of your estate plan is not going to be sufficient for business planning. In other words, you need to be thinking beyond that. All right, we have another question. It's a three-parter here. So we'll take this in chunks. I have a 3-part question. One, if I buy a house subject to and wrap it to a retail buyer and they default on payments, how do I take the house back? Or is my only option a foreclosure?
So I'll jump in first with my kind of unique situation. I've personally had to take a property back 3 times. And it was the same property all 3 times. So out of all the properties I've ever sold, seller finance wrap, just one property 3 times. And each time was via a deed in lieu of foreclosure. And so my little slide on my presentation, it says that we're very, very nice foreclosing lenders. And what I mean by that is we make a phone call. We in a concerned fashion, ask what's going on, try to find out if it's a permanent or temporary situation. If temporary, we do loss mitigation efforts, pay extra dollars per month, pay a lump sum at tax time, something of that nature, and see if they can catch up. And if it is permanent, then we say, sorry, but I'll give you plenty of time to get out. In exchange for that, I need a deed in lieu of foreclosure. And then if we have to up the ante a little bit and offer a cash for keys type situation, then we do that. I don't think I ever did get to cash for keys. They worked with me and gave me a deed in lieu of foreclosure. So that's my answer. We've never had to go to foreclosure. And out of all the files that have defaulted that we've closed, which is probably only about 20 out of thousands, only 1 had to go to foreclosure out of those 20. So it's kind of rare if you're acting, in a respectful fashion to your defaulting buyer.
Alan, what type of obviously the deed in lieu of foreclosure is a nice remedy. It's really just not anything different than an agreement among the parties to accept a deed instead of the foreclosure process. So transactionally, that could be cheaper, it could be faster, it can be all those things, but it doesn't carry with it the benefit of the foreclosure action, which wipes off all junior liens that there might be against the property. So somebody sophisticated like you knows to look for that. Where we see a lot of mistakes are people who just think this is just a cheap and fast foreclosure and I'm going to get the same benefits, which you don't. What kind of due diligence do you like to do to ensure on a deed in lieu that you're not taking it, subject to a whole bunch of stuff you didn't know about?
Yeah, so you're 100% correct. You have to confirm and I do a full title search, abstractors report, what have you. That costs anywhere between $150 and $200, and I gladly pay that myself, and confirm there's no liens. If there are liens on there, then yes, a foreclosure needs to occur to wipe those out, and we've had that situation before. And then lastly, my deed in lieu of foreclosure, well, probably everyone's, allows for a post conveyance foreclosure to occur, and specifically states that the lien is not released until released versus being released due to the merger clause. And so if a lien did pop up, a couple 4 weeks after, a couple months after, then that foreclosure can take place.
Interesting. So a post deed foreclosure. So after the deed in lieu has happened, language giving you the ability to still conduct a foreclosure if a lien were to be found.
Right. That's a really smart provision to have in there with the non-merger of title.
Yeah. Now I say all that stuff and it's, fancy drafting. I've never utilized it. I don't know if I need to maybe somehow rescind the current deed of some sort. But I guess I'll learn that if I ever have to use that.
Yeah, that was going to be my first thought. I'm like, I like the sound of that. Is that there's one thing to say things and then there's like courts that decide, well, whatever, but can you that's interesting. I like that. All right, so the second part to the question is, what if I buy a house subject to and wrap it to an end retail buyer and the due on sale clause gets called? What would be my options?
So I'll jump in since it's happened, and I need to tell T. Gordon to hop over to Harris County this coming Saturday to Rapp University, and we talk about all this stuff. But we've had this happen, and the options are, I guess we'll start with the most onerous. Pay off the note, sell the property, and have that note paid off via conventional sale. Those aren't necessarily viable. The end buyer wants to stay in that property. Can have the end buyer refinance, and we actually have that situation going on right now. So we're aggressively trying to get that end buyer refinanced because they did call the note. Well, actually didn't call the note due. The different situation, but same type effect. And then there's other options that we've done. We've actually done the deed flip flop, where deed back to the borrower, and then show that to the bank, and then deed it back to the end buyer. We've only done that on, I think, 3 occasions, and it's worked every time. On one of the occasions, I didn't want it to work because I knew the attorney real well and was going to tell him we're going to do this every single time. Let's get into a qualified assumption kind of situation, but they didn't find out. And then ultimately, and most recently, we're utilizing the trust vehicle. We place the property into a trust with borrower as initial beneficiary, and then send what I call my, hey, look, we're in compliance with Garn-St. Germain Act letter. And then subsequently we'll get the beneficiary interest over to the end buyer, and they'll just keep ownership in that revocable trust. So those are the steps that we've done historically.
Yeah, good information. By the way, 123 T. Gordon. Alan mentioned his Rapp University. I've in the top corner of the screen, I went ahead and put the barcode for Rapp University. So scan that. It'll take you right to Rapp University, and you can take a comprehensive course. You won't be sorry. But wanted to point that out. And just the third part of this question, I know you'll have something to say about this, Alan, and Sean or Drew, if you want to jump in on the other answers to any other stuff, feel free. But number 3 here is, if I'm wrapping a property to a retail buyer, how would I structure the insurance? Thank you in advance. So I know, Alan, you got a lot to say about insurance. Everybody does. That's maybe the least talked about, but one of the most important considerations, right?
Yeah. Yeah, it's in my opinion, it's most often the reason for a mortgage wrap transaction to fail is that insurance not getting put in place correctly. And there's now two choices. Um, the what we were doing for years and years and years is the seller does in fact terminate their insurance, cancel their insurance. The buyer is getting new insurance, and the insurance agent is going to know how to structure that and what they're doing. And I'm parroting words now. Buyer has to be the owner of the property has to be the primary insured, and then the seller's name needs to the seller who's the borrower it has to be on there somewhere, and so it's on there as an additional interest versus additional insured. And then the lender obviously has to be under that mortgagee clause, and the seller is a lender now too, so they're under that mortgagee clause. And so that's how we've been doing it. And now with the trust structures, the trust is essentially the insured with the beneficiary, who's the end buyer, is actually going to be named up there under that trust. What we're, obviously what we're doing is trying to keep the mortgage company from waking up and structuring this thing in a way that the person who's checking the boxes when they receive that declaration page are just checking all the boxes that need to be checked. So it's a changing environment and landscape, but so far it's been working.
Sean, let me ask you this. How does I pose this to you, Sean, because Alan doesn't they can't do the agreements for sale in the same way we can in Arizona out in Texas. But if, I know that agreements for sale are, you like that in certain circumstances and structuring a subject to transaction. How is the insurance structured in that scenario? Is it any different than Alan just explained?
It depends on the circumstance. Not circumstance. It depends on the structure of the seller financing. So if it's just a straight subject to with the purchaser paying the seller's mortgage and the seller's not carrying any portion of it back, then the purchaser will be listed as the primary insured with the seller as the additional interest in the whole thing. And if the seller is carrying a portion back, then you basically would list the purchaser as the primary, seller as additional insured, because they now have an interest that needs to be insured, i.e., whatever they're carrying back, and then list the lender as the mortgagee on all of them. So it's a little different if the seller has like a financial interest still in the transaction, as opposed to just staying on title to secure the repayment of the performance.
All right. If you're just now joining us, this is the Creative Finance Collective. With us today talking about creative finance. I'm Andy Fowler. We've got Alan Seschker in Texas, Sean St. Clair, Arizona, Wisconsin, and Drew Jenkins in Georgia and Alabama. So we're here to talk about creative finance and answer any questions that you have. Excuse me. And we will keep going until we stop getting any questions. A couple notes. Alan, you did get somebody scan that barcode. So T. Gordon, I think, might be coming to the class. But we've also got the NREM podcast barcode up there at the top. You might have seen that if you're a Facebook watcher. Go ahead and scan that. That'll take you to the YouTube page. Subscribe. We'd appreciate it. That allows you to connect in the best way possible with our content. What else is going out there in the creative finance space? Are there any new sexy or complex issues that you're seeing pop up outside of, the garden variety problems that we talk about almost every week on creative finance, like due on sale and some of those? What kind of things are you guys seeing?
So I've got two questions. I think both are actually for Sean. The first question is, why are you in Wisconsin during the cold time and then Arizona during the hot. Isn't that reversed? Probably the most important question.
Yeah.
But
So I'll answer that. So
okay.
what happened was we were up here during the summer, and our daughter ended up. Sorry, my probably animals in the background. My daughter ended up meeting a bunch of friends up here, and so she was doing online school, so we could be here during the summer and in Phoenix during the winter. And then she informed us that she wants to go to in-person school and potentially in Wisconsin. So we told her, well, if you're going to do that, you need to go through a Wisconsin winter. And that's why we're up here in the winter to try to scare her out of this, but it's not working. So,
there's only one other state that has set my last name is original. It's made up in Ellis Island 70, 80 years ago. And Wisconsin holds the other Sesker group. And so I did go up there one winter and went to sleep one night and woke up with, I think it was somewhere around 14 inches of snow. Wisconsin's not an option for me in the winter.
Yeah, no, it wasn't going to be an option for us. But our daughter there was a school she wanted to go to in Arizona, and she was too low on the wait list for open enrollment to go there. So, this was kind of her plan B. And so here we are. And I think we're going to be here for the next 4 years is the way it's going to work out. So,
well, good.
And then come visit us in July when it's 120.
Yeah.
Yeah.
So a question that's a little bit closer to creative finance stuff. Were you the drafter of the structure for the Morby method?
Oh, I did some of the paperwork on that. It's not fully being used as originally intended, I don't think, but I did do some of the paperwork on that.
That's exactly what I was going to say. So evolution and migration, as it evolved and migrated over to Texas, it got changed back around to having a note and deed of trust protecting that seller, which then gets us back into the problem area. So I asked the question, but also maybe post as a PSA. You can't contort the structure of that Morby method, what have you, because you're going to get yourself back into a prohibited structure or transaction. So you're either all in the way it was structured, or you don't do it. So kind of a PSA for those out there changing the structure.
Yeah, and I had the same thing with Sean as well. By the time it made it out to Georgia, it had metastasized even further. And I was like, I don't see how this works. And then Sean was like, that's because that's not how it works. It should be, you have to file your notice, of agreement or whatever first, and then you release it. And that's how you get paid. Because otherwise people were just, entering into contracts that contemplated ending the contract to then put two unrelated parties together, and somehow they were going to get paid and it wasn't going to be a commission. And it's like, you can't structure that way.
Yeah. So that would be, so there's novations, and then there's the Morby method is really, it's designed for a sophisticated seller who's also represented by counsel, where basically the parties enter into a business transaction post-closing type of arrangement.
Yeah.
And there's protections by doing that, such as operating agreements that don't allow the property to be sold and things like that. But it's a complex transaction, and frankly should never be done without both parties being represented by counsel.
I had one fella calls me, and he's trying to muddle through it, but he was not a sophisticated seller. And so I kind of told him, I said, if you're comfortable lending 100% to a party for 100% fair market value, 100% purchase price, then you can do this, because it's 100% funded with you as a seller finance carryback, essentially. And so I kind of told him not to do it. And then a couple of weeks later, he calls me back and says, well, I'm going to go ahead and do that. And then fast forward, it's a property that did depreciate in value, and he's all in an uproar, and I said, well, remember what I told you 2, 3, 4 months ago. So it's for the sophisticated folks only, and for the folks represented by counsel.
Yeah, that's really, and there is a, you know, a structure to do it, but it's not like you said. It's being metastasized into something that it's not. So
Yeah, it'll work itself out.
Yeah. All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour until we stop getting them. So make sure to post your questions. We have a long question here from a YouTube viewer. Panel question: in the creative finance world, I see people participating as capital providers, putting up money for escrow, then being taken out, or providing funds until a refinance is done. How does this money provider avoid being considered a lender and regulations of lenders when they do multiple deals? Is there regulation? Question marks. Banks as lenders have serious lending regulations to follow.
Stay away from consumers is rule number one. If you want to
Correct.
stay away from that.
That's exactly what I was going to say. I guess it applies if you're dealing with the consumers.
yeah, if you're lending for commercial, for business purposes, like to entities, and my understanding is you can, hard money lenders, you know, can, obviously there's usury laws and stuff you have to comply with, but I don't believe there's any, at least in Arizona, there's no regulations that would restrict giving commercial or business, you know, type loans to LLCs or companies that are doing business.
This earnest money lending, again, talking about Mr. Morby, he created that Gator funding, I think, which is the earnest money lending. I don't like that stuff at all, and the reason is we have one right now, and there's all these very strongly worded directions towards title. You know, you are authorized to release dollars to party, or earnest money dollars to party X if terminated on or before Y date, etc. But it doesn't take more than just an email from the seller saying, I'm withdrawing that authority, or the money belongs to me, or anything of that nature, a hint of a dispute in regard to the release of those earnest monies, and title's going to lock down. They're not going to release those dollars. One thing that I'm doing, I don't know if I should actually say this out loud now that I thought about it, but the earnest money dollars is going over to my law office trust account, because I have a lot more decision-making authority over that account than the account that belongs to me, the agency, the underwriter. So I got a little bit more latitude on my IOTA account. So I'm having the earnest monies over there until it becomes hard, and then put it over back into the title office.
Now, this doesn't help the Morby method people. In fact, it might cause consternation to some Morby method people. But, you know, in Arizona, unless the seller has a really good faith basis to object, if they cancel in the inspection period, it's a done deal. Like, you know, title companies don't even question it. Like, it's just kind of customary practice. If the buyer cancels during the inspection, boom, the money's released. Now, if the seller has some good faith basis to object, then maybe title throws up their hands. But sometimes they'll look at it and say, no, we're the decision makers under the contract, because the contract says they are. We're going to give it to the buyer because they had the ability to cancel during the inspection period. There are states, though, that the custom is a mutual release even during the inspection period. I don't know if, you know, Georgia, Alabama, Texas are like that. But what I would do in mutual release states, if I were a buyer, I would put it under contract and say my earnest money is not due till 2 days after inspection.
Yeah.
And then you don't have to worry about it. There is no mutual release concerns or issues. And then if you cancel after that, it's kind of like, well, you probably have lost your earnest money unless there's some other contingency out there.
Yeah, Georgia is the standard GAR forms. They give the title escrow agent, authority to determine which way money should go, and you can't really review it. But it's general practice. You get a mutual termination, right? Is it required? No, but that's just kind of the standard practice on these. Is both sides agree it's being terminated, and no one's going to make a fuss about it. Now, when they do make a fuss, and I've been doing this for what, like 12 years this year, is I finally had, for the first time, I had to pay money into court because the parties just had to fight over the earnest money. And I finally threw my hands up. I gave him a set amount of time and said, figure it out. And if you don't, I'm going to go hand it off to the court, pay it into the register, and, wash my hands of you folks. And unfortunately, that's exactly what I had to do. So there always is that too. Even if title locks down, if you tick us off enough, we'll go force you to incur, court costs.
So I got questions on that. I'm excited to hear that you did that. I've almost had to numerous times. So did you draft up the suit to go interplead, I guess, those dollars over to the registry? Or
No, of course not. I don't go to court. I had one of my buddies that does litigation handle all that. I literally just handed it off to him and paid the funds over and was done with it. So I did not do that.
Did you pay the attorney fees for drafting that up?
So we actually got the fees paid out of the earnest money.
Good. That's what I was hoping.
Yeah, so it reduced what they were fighting over.
Yeah, and I have used that threat before, and sometimes we're talking about $2,000, $3,000, $4,000, and I say it's going to cost a little bit more than the amount of the earnest money for us to get this over into the court. So y'all have got X period of time to finish up your little fight.
Yeah.
Yeah. And at the end of the day on that one, the earnest money actually wound up being split between the parties. So the judge looked at it and was like, neither one of you are acting in good faith. Right. And basically split the baby.
The wisdom of Solomon is pretty quick when you're dealing with problems like that.
Yeah.
So I'm looking at the next question, but before we get to it, because it deals with a second position forbearance lien, I wanted to ask you guys on subject 2, because I have some consternation in how these things are structured and who gets funds and who shouldn't get funds. But how are you guys dealing with partial claims now? Partial claims mortgages, because it's kind of a uncharted water, if you will, where HUD's paid out all these COVID claims and are taking these second position liens, and I have some consternation with like sellers getting cash out at closing without paying those partial claims off. How are you guys dealing with that?
Well, why don't you explain to everyone exactly what partial claims are?
Yeah.
That way I'll understand better too.
So a partial claim is basically the borrower gets behind on their mortgage and they claim COVID. And so they submit that to HUD, and HUD strokes a check of, let's say, I've seen them anywhere from $3,000 up to $25,000. They stroke a check to the lender. HUD strokes a check to the lender, and then brings the loan current, and then takes a second position lien against the property at 0% interest to be paid, upon sale or upon refinance or upon the full payoff of the underlying mortgage. And so they take this second position, but so you're dealing with HUD, and they are the mortgagee under the mortgage, and it is a mortgage that they take, and it says it right there, partial claims mortgage. And so I just kind of have it's like I said, somewhat uncharted waters, and I have a little bit of consternation with a seller, cashing out at $30,000, and HUD is just 6 months ago or 3 months ago or however long stroked this check to bring their loan current, and they're walking with this cash. Well, HUD's not being paid, and it's causing a little bit of consternation with me and concern as to what the fallout might be on that.
So
Certainly blow up deals, because I see those, the payoffs come through, and it really depends on the lender, but it seems to be more and more often that when you order the payoff from the first position lender, they will actually, at least generally, they will include a line item. Because obviously you have to ask them, what about the second position? Like, oh, look here at the bottom, and they'll give you another breakdown for the partial claim. So a lot of these first position lenders are collecting on behalf of HUD when you pay it off. Because from a title perspective, I need both released. So
Right. So there's actually a website you can go to
I
request
have
the
the
payoff on the
account.
part.
Yes, so I have the login for that. But in addition to that,
Yeah.
some of the lenders now are just handling collections when you order the first, right? So
Right.
you can hit at it on both sides. So that's something we have to be very careful of on title, is because you're right. You'll find sometimes people will get those things drawn out and then they'll sell their house 3 weeks later, like one guy did, and we almost didn't catch the recording,
Yeah.
right?
so why wouldn't you handle them the same way as a first time home buyer assistance program or any other HUD loan?
Yeah, I guess you can. I just, and if I'm less concerned if it's straight subject to and seller's not getting any cash.
Okay.
But, here HUD just stroked a check to bring their loan current. And it's been recent because it's, a COVID program. And you're letting the seller walk with a bunch of cash in their pocket while HUD's out there with a second after they brought their loan, basically paid money out of pocket to bring their loan, current for them and stuff. I don't know. I just personally have concerns with structuring it that way. Because it's kind of a novel new thing, and you're dealing with HUD. You're not dealing either with a lender or otherwise. I don't know. It's new, and I was just curious what you guys thought, or if you guys have even had to deal with it or addressed it.
Have you had any HUD loan called due per se?
No.
Me either.
No, but if all of a sudden that first were to foreclose at some future time and wipe out the HUD lien, and if they were to ever look in and investigate and be like, wait a minute, the seller walked from this thing with X amount of dollars and we were left kind of holding the bag. I don't know. It just doesn't. It doesn't pass the smell test to me. Whether that's how we should operate or not, I don't know, but it just causes me to kind of have a little bit of consternation, concern, regarding how that would look if it were ever investigated.
Yeah, it doesn't taste right.
No, it doesn't. That the seller would walk with money and HUD doesn't get paid after, and it hasn't been that long after they've written this check to bring their loan current. So I don't know.
So let's go ahead and, having said that, go to the question at hand that kind of started this, although it wasn't asking about that specifically. I'm looking at taking a property straight sub-2. It has a second forbearance lien HUD. Would you guys do a land installment contract or chance a regular sub-2 and transfer deed?
So we have closed those loans that they will go away after X period of time, and the buyer essentially signs off, understanding that they may in fact owe that forbearance loan to HUD. They need to understand that's a part of, they have put those numbers in a part of the project numbers to see if it's still viable for them, because we don't know if they're going to call those due. Those are kind of recent for us. And I think when they go to have the forbearance decision, I think they're going to look at the ownership to see if their borrower owns that property. But I don't know.
All right. All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour.
One thing I wanted to go
we've
back
reached
to,
the point.
yeah,
Go ahead.
if we could, is you're talking about on the commercial side about not being subject to banking regulations. And earlier we're talking about deeds in lieu on closings. If you do go the route of making commercial or non-consumer loans, one thing you can do in lieu of a deed in lieu that is becoming very common and that I think you should do is to get a pledge of ownership interest as the collateral, the UCC. Because then instead of having to go through a regular foreclosure or having to rely on a deed in lieu, and this is apparently becoming more and more popular among mezzanine lenders, right, under loan to own strategies, is you just foreclose on the UCC interest at a UCC auction, which has a lot less rules and is a lot faster. And then you take over the borrower. And since the borrower holds title, you have also gotten title without needing your borrower to agree to a deed in lieu, right? And without having to go through all the trouble of a true foreclosure. So I just wanted to throw that out as a potential strategy in the commercial space.
Yeah, and that really is a good strategy. I've papered a lot of those style of transactions. So basically, what Drew is saying is the way this would be set up or structured is you would have lender to borrower. The borrower is the LLC that will take title to the property. And then the owner of the LLC, whether it's a different LLC or an individual members, they would personally guarantee the loan obligation. And then their personal guarantee would be secured via a security agreement against their membership interest in the LLC that owns the property. So instead of having to do a foreclosure of the property, you actually foreclose on their membership interest and step in and just become the owner of the LLC that owns the property, effectively becoming the owner of the property. So the documents you would need would be the promissory note from borrower to lender, deed of trust or mortgage from borrower to lender, and then you would need a personal guarantee from the member or members, owners of the borrower entity or borrower LLC. You would get a personal guarantee, and then you would also get a security agreement from those individuals whereby you're securing your interest in their ownership of the entity itself. And then you would file with a UCC1 financing statement with the Secretary of State.
Yeah. I've got one on my desk today where there's two UCC ones. One is the typical UCC one against, the personality of the LLC. And then the second is the UCC one as to the pledge of ownership interest.
Yeah.
I like that strategy a lot. The biggest problem I have with it, though, is because I've done it. I've foreclosed an interest on a membership interest in LLC, and third parties do not know how to deal with it. Banks of the LLC, I can tell you right now, don't know how to deal with it. I've done it. I've taken over the membership interest, and I've gone to the bank and I've said, "This is ours now." And on the other line is the other side you just foreclosed on, and they're like, "No, it's not. They're stealing my bank accounts," right? And you know what the bank does? They shut it all down. And they're like, "Okay, this is locked down. This is like Fort Knox until you get a court order." And then like you're like in court. That's what's happened to me the last couple of times. But if you've got participating third parties, I agree. I love to foreclose on the UCC1 and the personal property.
Hey, one item. I don't know if it's in the creative finance space or creative space. Did y'all hear? Well, first off, do you know about the MV Realty, what I call scam, the 40-year listing agreement that they're doing?
Oh yeah.
Yeah, so, Georgia just passed a law to put an end to that, along with the squatters' rights. We bundled the two together. We got rid of MV Realty, and have turned squatting back into criminal trespass again. So we just got that passed.
So MV, we have a one of those little silly filings, and so used to look through the contract, see the problems, and then demand a release from MV Realty based upon defective nature or what have you. But when I reached out this last time, we got directed over to a trustee of a bankruptcy court in Florida, and thank goodness MV Realty has been pushed into bankruptcy. So I was kind of hopeful that all I do is just ask the trustee for a release and get it, but trustee kicked me back over to attorney for them because I think it's Chapter 11 bankruptcy, and I asked for a release, and the guy asked on what grounds, and I felt like going because your client is gross, but apparently that's not a legal basis for demanding a release, and so I copied and pasted all of the attorney generals who have filed suit versus MV Realty, and then also the findings from Georgia, and I think maybe Utah, or there's somewhere else that said, no, your things aren't good, the temporary restraining order out of somewhere. And we had the trustees CC'd on all of our conversations up until this one. And so I said, I guess it's based upon these states finding that you're acting wrongfully, and ask for the release. We don't have the response back yet, but hopefully it's on its way to killing MV Realty and getting rid of those interesting folks.
Yeah, that is interesting. Drew, I'm glad you brought this up. I was thinking about this in the context of the state of Florida, who recently passed legislation dealing with squatters as well. I had heard they did it. Apparently Georgia's done it now too. I'm curious, and I've been meaning to research it, maybe but in doing that, have they revised? Did Georgia go in and basically revise its adverse possession statute, or is adverse possession still as it was, or as it would have been treated in Georgia, and they've just addressed squatting in a different way? How is adverse possession impacted, if at all?
They have addressed squatting in a very different way, because like I don't know if it's true across most of the Southeast, but like in Alabama, for instance, you need to have color of title, right? Like if you're going to make an adverse possession claim to get a shortened period, you have to somehow prove that you at least believe that you have some basis to be on this person's property, right? Georgia, I don't know off the top of my head, but I would assume it's similar. The way squatting works now is, if somebody is squatting and you're the owner, you call the police show up, and they basically serve the person and say, look, you have 7 days to prove to us via some legal document why you have a legal right to be on this premises, right? Like you have to prove something.
So like shifts the burden to them.
It shifts the burden to them to prove it. And if they don't prove it, then, they're going to consider it to be a criminal trespass, and they're going to set them out basically. But if they do prove it, then it sets another clock, kind of like it is with title, right? Your title objection letters, you have so many days. And then if they turn the letter, you have so many days to respond. And then at the end of it, there will be a court to be held, no less. I forget what it is, but it's a very short time frame now. And they kicked it from superior court down to magistrate court, which is like our lowest level court, right? Sure. And they'll make a decision and kick them out pretty quickly, because it is a problem we have. I've got clients where you have squatters in homes without COs, right? So it's not even technically a home yet. It's not legally habitable. Wow. But you got squatters in it, and the police are like, it looks like a house. It is a house. It's just not legally fit for human habitation, and you can't get them out for literal months and months and months. So this is a game changer for us.
So they have the burden to show they have a legal right to do that. And I suppose that, like in a lot of cases, if they fail to show or fail to do anything, then it's just they lose by default.
The police will literally go set them out like within 3 days after or something. So I mean, it's a real short window. It's like a 10-day turn time from the time that you call the police out there to when they're either going to be hauling them off, or there's going to be a court date set.
So this doesn't this initial offer of proof essentially doesn't happen within the court. That happens that's a direct proof
with the police.
Made to the police, and if they
right.
don't receive what they're supposed to, they just come in and act.
Yep.
Wow.
It's going to be interesting.
Wow. We're living in fun times. The lawyers get to figure this out as we go, I guess.
Yeah, I can already see that they're going to produce a lease, and I already see it, right? They're going to produce a lease that's not signed by the owner or a property manager who is under contract with the owner, and there's going to be, a break in the chain, and they're going to get set out because you have to make sure that you're dealing with, the owner of the property. I can already see it.
Good information. Thanks for that, Drew. We'll have to monitor that more closely. I mean, I think obviously we've had Florida, Georgia's acted. I'm sure other states are going to act. It's clearly this is a problem that old common law statutes weren't sufficient necessarily to deal with. So we'll see. Guys, we've reached all of our questions. We've got just about an hour. That's pretty good. Thank you all for being on here, and let's do it again next week. See if we get as many questions. It was a good topic, good discussion, and thanks for your time.
Thank y'all. Good seeing y'all.
Have a
All
good
right.
night, everyone.